Hey there, and welcome to Beyond Borders, the Immigration Evaluation Podcast. If you're a mental health professional looking to expand your practice and make a meaningful impact by conducting immigration psychological evaluations, you're in the right place. I'm Dr. Mariella Shively, and on this podcast, we dive into the ins and outs of conducting immigration evaluations, helping you grow your practice while helping families stay together. So let's get into it. Today, we're going to talk about something that seems very simple on the surface, but actually has a lot of clinical, ethical, and strategic implications for us as immigration evaluators. We're talking about clients' declarations, also called affidavits. So specifically, we're going to be talking about what they are, how they're created, and the question that so many clinicians wrestle with. Should I read the declaration before I conduct the evaluation? Should I wait until after? Or should I avoid reading it altogether so I don't bias myself? And this comes up all the time in consultation, training, and it's not just a procedural question. It touches on trauma-informed care, on credibility, consistency across documents, our role boundaries, and even how we protect our reports from being sent back for revision because something doesn't match. So, declarations can be incredibly powerful documents. They are often detailed, emotional, sometimes graphic, and they form the backbone of many immigration cases, whether it's asylum or VAWA, U visa, T visa. And the ways that we interact with that document as clinicians can either strengthen the case and protect the client, or sometimes unintentionally create problems. So in this episode, we're going to unpack all of that. So if you have ever wondered whether reading the declaration ahead of time makes you biased, if you've ever had an attorney ask you to revise your report because it didn't match the affidavit, or if you've ever felt unsure about how much detail to have the client repeat during the interview, this episode is for you. So let's dive in. Okay, first of all, what is a declaration? What are we even talking about when attorneys say the declaration or the affidavit? Some people call it an affidavit. Some people also call it a personal statement. Some people just call it the story. But generally in immigration cases, it is a written document, basically a letter, that the applicant writes where they explain their case in detail. It's their narrative. It's their chance to lay out in a coherent way what happened and why they're asking for this benefit, this protection, this visa, whatever it is. So if it's asylum, the declaration is typically the story of persecution. What happened, who did what, why the person was targeted, what the person fears, what they experienced, how they got out, all of that. If it's a U visa, it's usually describing the crime that they were a victim of, what happened, the context, what injuries or harm resulted, how they cooperated with law enforcement, etc. If it's a VAWA, same deal. They tell the story of the relationship in detail, how it started, when the abuse began, the pattern of abuse, escalation, all of that. And usually the declaration also includes some basic background information. Things like, I was born here, I grew up there, I came to the U.S. this year, I lived with this relative, I worked at this job, I have these children, I've moved around. It's almost like a little timeline. And then it goes into the core events that are relevant for the legal claim. And I want to pause on something. VAWA declarations, in my experience, tend to be pretty detailed, often very detailed. And one reason is because a lot of times they don't have a ton of other evidence. So the declaration becomes extra important. They want it to be very clear, very specific. So instead of saying something general, like he started insulting me, the declaration might say, well, he called me this, he called me that, he told me I was worthless, he said that he would have me deported, he said no one would believe me, that kind of thing. It can get very granular, and sometimes it reads almost like you're right there, and that level of detail can be incredibly useful legally. Now, declarations are a pretty standard part of the application. In general, the applicant is the one who writes it. But in many situations, attorneys help them. And help them can mean a lot of different things. Sometimes the client writes it in their own language, and then the attorney arranges translation. Sometimes the attorney reads the draft and says, okay, well, we need to expand here, expand there. You need more detail about this part. You need dates, you need locations, whatever. And then the client revises it. Sometimes the attorney or staff, usually staff, interviews the client, takes notes, and then someone turns those responses into a polished declaration. That's also very common. And that's where, honestly, we sometimes start to run into trouble. Because when a paralegal or a staff member drafts it in English and the client doesn't speak English, a lot of clients will tell me that they never actually read it. Or perhaps they read it in a rushed way, or someone summarized it for them. They just signed it because they trusted the office. And you can often tell who wrote it, right? If it's perfectly written, very organized, grammatically correct, legal-sounding phrases, and then you meet the client and you realize that they have very limited formal education or they speak in a very different way, you can tell that the declaration likely wasn't written directly by them. Now, does that automatically mean something unethical happened? No, absolutely not. Legal offices do assist. That's normal. But what matters is, does it accurately reflect the client's story? Did the client actually verify it? Did they understand what was written? Because that's the piece that can come back to haunt the case if there are inconsistencies. And so that brings me to the next big question, which is something clinicians ask me a lot, and I hear very different opinions about. Do I want to read the declaration before I conduct my interview? Do I want to read it after? Or do I not want to read it at all? And I'm going to talk about all three approaches because you will encounter colleagues who do each one, but I'm also going to tell you what I do and why. First, practical reality. Many times the person will not have the declaration before the interview, and that's because it hasn't been written yet, or it's in progress, or the attorney wants to wait. I have come across several attorneys who say that they actually prefer to draft the declaration after the psychological evaluation is completed. And when you first hear that, you might think, wait, why? Isn't the declaration supposed to be foundational? But they usually have reasons, and I want to be fair about those reasons because they're often legitimate. One reason attorneys have given me is that they believe the client will open up more to a mental health provider than to a paralegal or a lawyer. And that's true. A client may feel judged in an attorney's office, or they might feel that they have to perform a certain way, or they may fear saying something to them, something wrong, or they may not trust the process or the attorney yet. But with a clinician, especially for trauma-informed, pacing things well, they may be able to talk more freely. Another reason attorneys give is that they don't feel well equipped to handle what happens if the person decompensates when talking about trauma. And I've heard this directly from attorneys. They'll say, I'm not trained in what to do if someone starts hyperventilating or dissociating or having a panic attack or crying uncontrollably. I don't know how to ground them. I don't know how to slow it down. I don't know what to do. And honestly, that makes total sense to me because it's true. Most legal professionals are not trained for that. They're skilled in law, but not in trauma stabilization. So sometimes they want to avoid potentially harming the client, or they want to avoid a situation they don't know how to manage. And they'd rather the mental health provider do the first deep trauma narrative. Now, are there situations where a lawyer is just overwhelmed or maybe a little too reliant on the evaluation report to shape the declaration? Possibly. That can happen. But I do want to acknowledge the legitimate reasons that I've been given because those reasons actually line up with good trauma-informed care. Okay, so then if a declaration does exist before we meet the client, do we want to see it? In my opinion, yes. Often I do want to see it. And the main reason is inconsistencies can be devastating in immigration cases. So let's talk about this carefully. Cases like U visas and T visas, these are typically adjudicated administratively, meaning there's an officer reviewing the packet. They're looking at everything, the declaration, the police report, the certification, any witness statements, any medical record, any prior immigration filing, and then our psychological evaluation report. any inconsistency between submitted documents can be questioned. And when it's questioned, one of two things typically happens. It can delay the case because they send a request for evidence, like an RFE, asking for clarification or more information, or it can harm credibility, and credibility is everything. Sometimes it can even lead to a denial if the inconsistency is significant and not adequately explained. So if the client tells me during the evaluation, there were 3 men, their faces were covered, and one had a gun, but the declaration says there was 1 man with a gun, I want to know which one is it. Because an adjudicator might say, okay, well, which is true? And the implication becomes, were you lying in the declaration or are you lying now? And I want to avoid that. Now, it is also common that we have inconsistencies between the client's memory and official documents like police reports. This is so common. The police report might say, a victim reported 3 men approached her. And then in the evaluation, the client says, no, it was just 1 man. Now, that doesn't automatically mean deception. It can mean a lot of things. It can mean the officer wrote it incorrectly. It can mean there was a language barrier. It can mean the client was panicking and confused, or that a neighbor interpreted poorly. It can mean the client was trying to describe a group and the officer concretized it as 3 when it wasn't 3. It can mean trauma memory fragmentation, where the person remembers pieces but not the full configuration clearly. It can mean so many things. But here's the point. We want to be able to explain inconsistencies, not ignore them. So I might ask the client, well, I noticed the police report says 3 men, but you're saying 1. Can you help me understand that? And then the client might say, well, I don't know why the officer wrote that. I told him 1. Or, well, I was really nervous. I didn't understand what they were asking. Or they might say, well, my neighbor was translating and I don't know what they said. So whatever it is, if we catch it early, we can document it appropriately and the attorney can address it. And this is especially important if the declaration was already submitted and we're now responding to, say, an RFE, because then inconsistencies are already on the radar. We absolutely have to clarify. But even if it hasn't been submitted yet, if the declaration is still in draft form, seeing it ahead of time can prevent a problem later where the attorney reads your report and says, oh, this doesn't match the declaration, and then they want you to revise your report. So I like to avoid that situation. Now, there's another reason I like to see the declaration ahead of time, and this is more clinical and more trauma-informed. Sometimes the events that these clients went through are extremely traumatic, and our job as evaluators is not to detail every single thing that happened. That's precisely what the declaration is for and what the attorneys do when they write their briefs. Our job is to explain, how did it impact the person psychologically? What symptoms developed? How does it impair functioning? How does it relate to the psycholegal question in the case? So if I already have in detail what happened, let's say, for example, the declaration describes a brutal sexual assault or torture or severe domestic violence, I don't need the client to repeat every graphic detail to me. I might need a basic confirmation of key points, and I might need clarification of timing or sequence, yeah. But what I really need is, how did it affect you? What were you thinking at the time? Did you think you were going to die? What did you feel in your body? What happened afterwards? Are there nightmares, panic, avoidance, hypervigilance? Were you able to sleep? Were you able to work? Were you afraid to leave the house? Did you stop going to certain places? Did you avoid people? So those are the things that I need to understand. And for that, I don't need to re-traumatize the person by having them rehash every detail if I already have the detailed narrative in the declaration. Because for trauma survivors, having to repeat the story over and over can be painful. It can be destabilizing. Now, can it sometimes be therapeutic? Of course, in therapy, with pacing and a treatment frame. But this isn't therapy. This is an evaluation. So I like to use the declaration as a way to reduce unnecessary repetition. I can say something like, Well, I read what you shared in your written statement. I'm not going to ask you to repeat every detail, but I am going to ask you some questions so that I can understand how this affected you. That is trauma-informed. It communicates respect, and it keeps the evaluation focused on the psycholegal question. Now, you might hear some clinicians say, nope, I don't want to read anything. I want to start from scratch. I don't want to be biased. I want to be neutral. And I get it. It comes from a good place, wanting to be objective, wanting to avoid being led by a narrative, wanting to avoid confirmation bias. But I don't agree with that approach as a blanket rule, because I don't think being well-informed equals being biased. I think the more information I have, the more prepared I am to conduct a thorough and accurate assessment, and I can still remain objective and neutral. In fact, I would argue being unprepared can create its own kind of bias, because when you don't know the story ahead of time, you might ask questions in a way that is too broad or too intense too quickly. You might accidentally push the person into recounting details that are unnecessary. You might miss key issues that you could have clarified gently if you knew that they existed. So for me, reading the declaration when it's available is part of being prepared. Now let's talk about how to read it, because this matters too. I don't read it like I'm reading a novel. I read it like an evaluator. So I'm looking for the basic timeline, key events and dates as much as they can be known, people involved in relationships, whether there are parts that are vague or inconsistent, whether there are statements that might trigger inconsistencies with other records like police reports, and also whether there are details that are so graphic that I want to be careful not to ask the client to repeat them. And then in the interview, I'm very intentional. I might say, well, in your statement, you wrote that the incident occurred in 2018, but earlier you mentioned 2019, so help me understand the timing. Or your declaration describes threat after the incident. Tell me what that did to your sense of safety. So I'm using the declaration as a roadmap, but I'm not replacing the clinical interview with a declaration. The interview is still essential. We still need to assess consistency, affect, symptoms, functioning, all of that. But the declaration helps structure the interview and reduce harm. Quick break. If you love what you're hearing and want to get started with immigration evaluations, grab my free introductory guide to immigration evaluations. It's linked in the description box, and it is packed with everything you need to know about the different types of evaluations, writing strong reports, and avoiding common pitfalls. Download it now. Now let's get back to the episode. Now I also want to talk about a tricky situation when you suspect that the declaration was written in a voice that doesn't match the client. This comes up a lot. You meet the client and you think, this is not how this person speaks. Or the declaration contains very sophisticated emotional language, like, I experienced severe emotional distress and persistent intrusive recollection. And you're like, okay, that sounds like it came from someone else. So when that happens, I don't accuse anyone, that's not our role, but I do start to gently assess, did the client actually know what was in there? Did they review it? Do they understand what was submitted? So you can ask very simple questions like, did you get a chance to review your declaration? Was it written in your language first, or was it drafted in English? Did someone translate it for you? Is there anything in it that you feel is inaccurate or incomplete? And sometimes clients will say, no, I didn't read it. And that's important information because it means there could be inaccuracies that they're not even aware of. Now, there's also something else. Even when clients did write it themselves, memory changes over time. Trauma memory can be fragmented. Details can become clearer later or sometimes less clear. People might remember a date differently, or they might remember the sequence differently. So the existence of an inconsistency doesn't automatically mean that someone's lying, but it does mean that we want to catch it and address it proactively. Because the immigration system is not trauma-informed. Let's just be honest. The system often expects a neat, linear narrative, and human memory, especially trauma memory, is not always neat and linear. So part of our job is to help translate that reality in a clinically sound way without making excuses. but also without allowing credibility to be destroyed by something that is actually explainable. Okay, so we've talked about why declarations matter and the timing question before, after, not at all. Now I want to give you some practical guidance, like what do you do in real life in your workflow? So here's a way to think about it. So first scenario, the declaration is not written yet. So in that case, you can't read it. So what do? You do your evaluation as usual, but you're extra careful about documenting factual details. So you might say, Ms. So-and-so reported, blah, 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 and you keep your language clear. And if the attorney is planning to write the declaration after the evaluation, you have to be mindful. Your report might become a template for their declaration. So you want to be careful about how you phrase details. You want to be accurate, and you want to avoid unnecessary specificity if you're not fully sure. So for example, if the client's unclear whether it was March or April, don't just put March, just document the uncertainty. Second scenario, the declaration exists, but it hasn't been submitted yet. And that's actually the ideal scenario for many of us because you can read it, you can catch issues, and the attorney can still revise it. And the last scenario is the declaration was already submitted. And so here it's even more important to be consistent or to explain any discrepancies because what's submitted is what the government is reviewing. So in that scenario, I read it carefully and I am specifically on the lookout for anything that my client might say differently in the evaluation. And I'll address it both during the evaluation, of course, and in the report. Now, lastly, I want to zoom out and say something that I think is important for clinicians to hear. Reading a declaration does not mean that you accept it as truth without question. It means you're informed about what has been claimed, what has been presented, and what the client is asserting in their case. And then you do your job. You assess, you clarify, you evaluate symptoms and functioning, you look at internal consistency, you document appropriately. Also, when we talk about bias, we have to be realistic. We're always coming into an evaluation with some information. We have a referral question. Sometimes we have a brief summary from the attorney. Sometimes we have police reports. Sometimes we have medical records. Sometimes we have prior evaluations. So the idea that we can come in as a blank slate is not really true. The real standard is not blank slate. The real standard is objective, fair, clinically sound, and transparent about your sources. And I'll say this too. If you're worried that reading a declaration will bias you, the solution isn't to avoid information. The solution is to be disciplined in your thinking, to be aware of confirmation bias, to actively look for alternative explanations, to ask clarifying questions, to document carefully. That's a clinician's skill. Now, before we end, let's go back to the trauma piece for a second because I really want to emphasize this. Declarations can contain very graphic, painful details. So when you read them, you want to prepare yourself emotionally too, because you might be reading very intense material before you even meet the person. And then you meet them and they're sitting right there and you're holding all that information. So part of your preparation is not just clinical preparation, it's also self-regulation. How do you stay grounded? How do you maintain a calm presence? How do you avoid looking shocked sometimes? Or how do you avoid inadvertently communicating judgment or pity? Those things matter. And you can use the declaration to pace your interview. You can say, okay, now I'm going to ask you some questions, and if anything feels too intense, we can slow down. You can normalize, you can ground, you can take breaks, you can do all of that. Because again, this is not therapy, but it still involves human beings talking about traumatic things, and we need to be responsible. Okay, so let me summarize my main points in a very practical way. A declaration or affidavit is the applicant's written narrative of their case, and it is standard in many immigration filings. It may be written by the client, drafted with attorney support, or drafted by staff based on an interview. And not all clients fully review what's written, especially if they don't speak English. Inconsistencies between the declaration, your report, and other documents can lead to RFEs, delays, or credibility problems. So when available, reading the declaration before the evaluation can help you identify and clarify inconsistencies early, can help you avoid unnecessary retraumatization by not forcing repetition of graphic details, helps you focus the interview on psychological impact and functioning rather than retelling, and reduce the likelihood that you'll be asked to revise your report later due to any inconsistencies. You can remain objective while being well-informed, because neutrality is about your thinking process, not about depriving yourself of information. And I'll end us with a gentle invitation for you as a clinician to develop a consistent personal policy, because whatever you decide, whether you want to read before, read after, don't read, you want to do it intentionally, not randomly. So my policy is this: if it exists, I want to read it. If it doesn't, I proceed carefully and I document clearly. And either way, I stay trauma-informed and focused on the psycholegal question. What is the impact? What are the symptoms? What is the functional impairment? What is the clinical interpretation that is relevant for the case? Because at the end of the day, the declaration tells the story of what happened, but our report explains what that story did to the human being living inside it. Thanks for tuning in. If you loved this episode, I'd love to hear your thoughts. Leave a review or shoot me an email. I'll see you next time.